Good evening, I'm Pinky Webb. Tonight we ask the questions, we tackle the issues, we clarify matters, and we get on point. The House of Representatives formally pushes back against the Supreme Court's ruling on the impeachment case of Vice President Sara Duterte. In its motion for reconsideration, the lower chamber cited alleged factual errors and retroactive imposition of new rules. Did the High Court get it wrong when it declared the articles of impeachment as unconstitutional? Let's get on point with retired Chief Justice Reynato Puno. CJ, pleasure to have you. Finally, sir, maraming salamat po sa inyong oras.
Thank you.
All right, let's begin with this. The PhilConsa came up with a statement already, CJ, no? And basically, it's saying that two things. There's the procedural aspect, and then the second is the substantive aspect. But before I go to that at length and ask you about it, I wanted first to get your thoughts on the decision of the Supreme Court. Was it right for the Supreme Court to decide on this, or just simply allow Congress to pursue this, considering there is separation of powers? And, may I add, should they have at least asked for oral arguments? Your thoughts?
On the first question, the Supreme Court may have jurisdiction over the case. But the matter of timing its interference is another question. You will remember that these two cases have been pending with the Supreme Court for quite a long time. And the Supreme Court did not issue any restraining order to prevent the case from going to the Senate impeachment court. And at the time the Supreme Court decided to assume jurisdiction, the same issue, whether or not there was a violation of the one-year rule, was already also for consideration of the Senate impeachment court. The question is the timing proper? Again, some may say the timing is right, the others may contradict. But
what do you think of the timing?
Personally, I would have let the Senate impeachment court resolve the issue. After all, the party that feels prejudiced by the ruling can always go up to the Supreme Court on a question of law.
Oral arguments, the follow-up question to that, CJ. Should the Supreme Court at least have called for oral arguments, since the two petitions were lodged before them sometime second week of February?
These two cases are what we describe as transcendental cases. The ruling affects the principal architecture, design of the Constitution. Separation of powers, checks and balances, political issues. And normally, the court would call for oral arguments on these cases of such a magnitude. Not only call for oral arguments, But the practice is for the court to solicit the opinions of experts, the amicus curiae. And sometimes they solicit these opinions not only on the part of one expert, but on the part of several experts, so that the various dimensions of the case would really be brought to the Supreme Court for their consideration. And they call for oral arguments, especially when the facts are highly contentious.
Do you think that the Supreme Court erred in not calling for oral arguments?
In a sense, yes. And the reason for that is the criticism that the court now faces. And one such criticism is the question about the correctness of their findings of facts. If perhaps there was an oral argument, this criticism could have been avoided.
I heard that also echoed by Justice Antonio Carpio and also former Chief Justice Artemio Panganiban, also saying that if the court allowed oral arguments on the case of the PhilHealth funds being moved from transferred to the Treasury, such a topic as this should have had the same kind of oral arguments or presentation because of the importance of the topic.
That's right. And the court does not lose anything by calling for oral arguments.
Do you think, CJ, there is a chance for the court, I don't know if the right word would be redeem, but because a number of you whom I've spoken to have been on this idea or this assertion or this insight that an oral argument should have been in order. Do you think that because people like yourself, the former Chief Justice Artemio Panganiban, former Senior Associate Justice Carpio, former Justice Adolfo Ascuna, also former Justice Conchita Carpio Morales, pretty much were all basically saying the same thing. I just remember from Justice Conchita Carpio Morales, she was saying the definition of initiation is when it reaches the Justice Committee of the House. That's what I remember. But when you have all former Chief Justices and former members of the judiciary saying that there should have been an oral argument, do you think this will open up the minds of the present justices in the Supreme Court to actually call for an oral argument?
I would say that if the court would call for an oral argument, these various issues, especially the factual issues, would be established better. And if these factual findings are weighed on the basis of the contentions of the opposing parties, the decision would be better appreciated and accepted by the public.
Before we go to the statement of Philconsa, I also wanted to ask you this. I talked about it briefly a while ago, but I wanted to rephrase the question. Should have there been what they call a judicial restraint by the SC on this issue?
I would proffer the view, and this view is shared by the other justices and by most of the academicians, especially those teaching constitutional law. The view is that on the substantive aspect of the case. I mean, especially that part of the decision that impose 7 new conditions. The court should not only exercise restraint. That is the part which is the political process of the impeachment process. And that political part means that the court should inhibit from interfering with the decision, with the conduct, with the action of the House. And that is very clear from Article 11, Section 3, that vests in the House the exclusive power to initiate the impeachment process. So textually, you can see from the Constitution that this power was clearly vested in the House of Representatives by the use of that word exclusive. That immediately eliminates the possibility of intervention by any branch of government, including the judiciary. Exclusive means that the power cannot be shared. It's that simple.
It's vested in the House of Representatives.
Yes.
What do you say to the part of the ruling of the Supreme Court, especially by the Ponente, wherein it said that the end does not justify the means?
I do not know whether that is an appropriate principle to use. The traditional rule in interpreting the Constitution is the holistic process, whereby you balance all the principal values embedded in the Constitution. And in these 2 cases, what the court should have considered is first the provision of the Constitution on accountability. The provision of the Constitution that says a public office is a public trust. And if you look at the debates in the Constitutional Commission, you know, the commissioners there saw to it that this value is given primary importance. And that is the reason why they made it easier to impeach public officials on the matter of the votes necessary. In the prior constitutions, it was more difficult to impeach public officials. But in the 87 Constitution, the commissioners thought that given the evil of corruption, they thought that this value of accountability should be given primacy.
Quoting some parts of that decision, it said that for the first time, impeachment was seen as a measure, as you're mentioning, CJ, of accountability for public officers, rather than just a mere method of removal from public office. That was part, I think that's just looking at it, page 41 of the decision. Here's something that I'm still very confused about. It says this: impeachment, therefore, is not solely a political process. That's where I want to understand where the political, the judicial, the sui generis term actually comes in. Impeachment, therefore, is not solely a political process. It is a sui generis constitutional process that is primarily legal, but with political characteristics. So it's legal with political characteristics. Any interpretation regarding its procedures, grounds, and consequences must be read with the entirety of the Constitution. Decisions regarding whether to file articles of impeachment or to acquit or convict must be based upon clear charges supported by sufficiently clear and convincing evidence.
Yes. Again, that is correct, that the impeachment process is sui generis. Sui generis, meaning that part of it is political and part of it is legal. The question is, what is political and what is the legal part? It is very clear that the political part is the initiation process. The legal part is the trial stage process. That is the part played by the Senate impeachment court when the respondent is tried, and after trial, where the impeachment court gives its judgment whether guilty or not guilty. So that should be clear, which is the part that is political and which is the part that is legal.
So political is the House, legal is the impeachment court, the Senate.
The political part is the part played by the House in initiating the process. And when you say political, that means to say that the judiciary should not interpose its power in the conduct of the impeachment process. If the conduct of the House is erroneous, take for instance, if the House would file a deficient article of impeachment, and it is dismissed by the Senate when the case is tried, then the responsibility of the House is to the people. That is what
and then
is
that
meant
still
by
becomes political in nature. Okay.
The House does not answer to the judiciary. It answers to the people because they are the elected representatives of the people. And we should remember the provision of the Constitution that says all power emanates from the people. The people is sovereign in all aspects.
So political is the House. Before we go on a break, I know they're telling me to go on a break. Political is the House, legal is the Senate. My question is this, CJ, before we go on a break.
Yes.
Are you saying, therefore, it was wrong for the Supreme Court to have decided on this?
Yes, with due respect to the Supreme Court, I would say that the interposition of judicial power in the political part of the process is very questionable, especially when the court wrote these 7 conditions to guide the House in the conduct of the initiation process.
We're going to talk
Those
about
7 conditions are nowhere in the Constitution.
We're going to talk about that, but we need to take a very short break. We'll continue our discussion with former Chief Justice Reynato Puno when we return. Stay tuned. This is On Point. Welcome back. Still with us, former Chief Justice Reynato Puno. Again, let's go back to the statement of Philconsa. This is 4 pages. Let's first go to the 2 points. There were 2 points to me, CJ, that you were trying to stress here. First is that you were urging the Supreme Court to review what is called the factual basis of its ruling with ultra care. I think it even said the ultra care was in bold letters, with ultra care with regards to its findings of facts. Basically saying that the SC is not a trier of facts. Kindly elaborate, CJ. Ultra care with its ruling.
Yes, the Supreme Court, by its nature, by its design, is not supposed to be a trier of facts. The primary function of the Supreme Court is to interpret the laws, not to try the facts. So that usually a case goes to the Supreme Court from the trial courts where the facts are really established. And then these cases that come from the trial courts go up to the Court of Appeals. And the Court of Appeals, again, looks at the correctness of the findings of facts of the trial court. And then the case ultimately goes up to the Supreme Court. That is the normal route of a case. So by the time the case goes to the Supreme Court, the facts are well established. But in these two cases, you will note that they were directly filed with the Supreme Court. And the problem is that the case involves facts that are highly contentious, meaning that the facts are disputed by the parties. So it would have really helped if the court, if it chose to be a trier of facts, at the very least, it should have called for oral arguments. As it is now, you have a lot of finger pointing that some of the findings of facts of the court are of dubious nature. They say that the significant facts were sourced from news reports. And these news reports are unverified reports. They partake the nature of hearsay evidence.
Up until it's authenticated, would that be correct, sir?
Yes. So on the other hand, the critics of the court say that the facts could have been established if the court look at the official journal of the House of Representatives. That is why we took the position that the Supreme Court should revisit these findings of facts with ultra care.
Basically talking about, well, of course, two things. One is the one-year bar rule that the Supreme Court decision said the House violated. And of course, the second one was there was no due process. So we don't have a lot of time. I have to go to the second part of the Philcon's statement, where basically there's grave concern on the imposition of 7 mandatory rules the HOR, the House of Representatives rather, should follow when filing an impeachment complaint. So I have with me, obviously, the 7. Why is this of grave concern, CJ? Do you even find this? Because I tried to look for it in Article 11 of the 1987 Constitution. I found nothing. In fact, what I found was basically it's up to the House to promulgate its rules on this.
Right. And again, the right of the House to promulgate its own rules is very clearly stated in the Constitution. And that means it's not the Supreme Court that will write the rules for the House. Perhaps some rules of the House can be, later assaulted as unconstitutional. So let it that be. But certainly, the court cannot write for the House the rules that should be followed by the House. And more than that, if you look at the wisdom of the 7 conditions imposed by the court, I agree with the impression that these are terrific barriers imposed by the court.
Is it going to make it harder to impeach officials
That's
because
right.
of the 7 rules or the
It's
7
very
conditions?
difficult to impeach these high public officials. And again, as I say, by doing that, you are not giving proper value to the provision of the Constitution on accountability.
What I want to further understand is that if it is written in Article 11, Section 3, Paragraph 8 of the 1987 Constitution that actually says it is the House that shall promulgate the rules, is it a judicial overreach? Would that be the term when the Supreme Court set forth the 7 conditions that the House or the court should follow or the House should follow in impeachment complaints?
Well, it can be called an overreach in the sense that the Supreme Court should not have done that.
Do you see any reason, CJ, why this was set forth? Do you like to venture a guess, if you will?
I really cannot comprehend the imposition of these 7 rules. They are not in the Constitution. And as I said, and as others say also, you know that the conduct of the initiation of the impeachment process is the political part of the impeachment process, and the court, should not enter the political ticket. Because if the court, goes to the political ticket,
Okay.
it's very dangerous. The creatures that will be met by the court there would be unknown, and it will be exposed to terrible danger.
Unfortunately, Chief Justice, I only have 1 minute left.
Okay.
This is an important question. Do you think the Senate should vote on this issue of the Supreme Court declaring the articles of impeachment unconstitutional? Because there is a plan to tackle this tomorrow and possibly come to a vote. Or should they wait for a decision from the Supreme Court after the motion reconsideration filed by the House of Representatives through the Solicitor General?
The latest development is that the House has already filed its reconsideration. And the court, I understand, has asked BP Duterte to comment on the motion for reconsideration. So in light of these developments, what is the more appropriate thing for the Senate to do, considering the decision of the Supreme Court that says, number 1, it is immediately executory, and yet number 2, it's not yet final. The happy compromise, I would like to think, if the Senate would like to dismiss the case, because it says the decision is immediately executory and yet not yet final. I think the happy compromise is for the Senate, if they want to do it, to dismiss it, but not with finality. to dismiss it without prejudice. That means, you know, if the Senate dismisses it without prejudice, the case can still be revived, depending on whether the Supreme Court will modify its decision or reverse its decision. I think that is the compromise that should be followed by both houses.
Former Chief Justice Reynato Puno, pleasure to have you. Thank you, sir. And I hope to speak to you again. Maraming salamat po sa inyong oras.
Maraming salamat din.
That's On Point. Join us again tomorrow, 7:30 p.m. here on BNC, the Billionario News Channel. I'm Pinky Webb. Thank you for watching.